Welcome back once again. So today we will be looking on to what is intellectual property rights, what is the importance of preserving the intellectual property rights when it comes to businesses. So as you all know, intellectual property rights conserves your right about your intellectual contribution. So you might have heard about copyrights, you might have heard about patents, you might have heard about trademarks which comes into this regime. So when it comes to business, you have to protect your idea, you have to protect the product that you have just brought into after investing a lot of money in research and development. So how do you just protect these rights? And how do you face the business competition with the help of intellectual property rights? So that is the point of discussion with regard to IPR in startups. So what is basically an intellectual property? The World Intellectual Property Organization defines intellectual property as creations of mind such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. And in simple terms, anything that you create by applying your mind or intellects becomes your intellectual property. For example, you are setting up a business of your own and you have designed a logo for your brand, and that logo is your intellectual property. And similarly, a scientific invention is also an intellectual property. So once you're using a logo, for example, you might have set up your business and you have designed your logo and your product has been accepted by the people, and this logo and your brand name, everything gets importance. So it is easy for the competitors to mimic your logo or mimic your brand name and get your customers attracted to the other product that is propagated in your name or similar name. So that is actually a breach of interest, or your rights are being breached at this particular point. So in order to avoid that, in order to protect your property, that is the intellectual property that you have created out of your intellect, this can be protected by the intellectual property rights. So for that purpose, the World WIPO, that is a World Intellectual Property Organization, has created a rule or an act has been promulgated in order to protect the intellectual property rights. So, what is there about the intellectual property rights? When you create a logo for your brand, you will want it to be unique and also resonate with your brand. You want to stand out from your competitors and also make sure that your ideas are not copied or misused. And this is where intellectual property comes in. And intellectual property rights are given to creators for a specific amount of time. So you cannot have the intellectual property or the rights for unlimited time, but there will be specific time for that, and during that time you will be able to reap the benefits of your contribution. And if at all somebody wants to replicate your kind of an intellectual property, they will have to pay you a concerned license fee for that purpose. And during this time, the creator is protected from infringement and can license their product for manufacturing in return for a loyalty. And the legal rights provided to the creator or inventor or intellectual property are known as the intellectual property rights. And every creator enjoys certain privileges provided by the law that protects the creators from infringement or misuse of their work without their explicit permission. Intellectual property rights are also aid creators in putting their work to use for the general public by allowing for commercial licensing. So this is all about intellectual property rights, is all about registering what your property is. Be it an idea, be it your product, be it your logo, you will be able to gain a protection for your kind of a intellectual property. And if somebody wants to use it, they have to get a permission from you by means of a license and by payment of the royalty. So this gives a protection of usage of your kind of a work or your kind of a property for other people. So what are the types of intellectual property? So what are all the things that you can reserve for yourself? So you need to have a better idea of this when you are going for the business. For example, in the case of business, we have the trademarks and also the patents, and sometimes when it comes to industrial designs, that is applicable. So what are exactly all these things? So in the case of trademarks, it refers to the symbols or logos or signs or words or sounds that are unique to a product or business. For example, you might remember that Twitter has a blue bird logo and it is representative of its brand. It is protected by the IPR, intellectual property rights. So trademarks actually represent that company, the quality of the company per se. That is, if you are familiar with the brand and you are very satisfied, you just look on the logo of it, and the logo creates a value of the product in the customer. So the trademark is important. So if somebody is mimicking your trademark, the customer might be under the impression by looking at the trademark, it is a similar kind of a product, or it is a product of the same company. So such kind of misrepresentations can occur. So this can be avoided by registering the trademark. Once you have a registered trademark, nobody can use that particular trademark. And if at all somebody uses a similar kind of a thing, you can go for the breach of your rights. You get the protection of the court of law. So the second right is copyright, and copyright is applicable to any published work such as books, artwork, or songs, or web content, or films, or other kind of literary kind of items. For example, your favorite cartoon, Tom and Jerry, are artwork copyrighted by Disney. So any artwork can be copyrighted. So in order to reproduce this literary works, for example, the journals that publish the papers, if you have to get a copy, you have to, or if you have to reproduce that as such, you have to get the copyrights from the journal publishers. So similarly, if you want to take a copy of the book, you have to get the permission from the publishers, only then it is legal. Or otherwise, if you are taking unauthorized copy and distributing, you'll be able or the publishers will be able to sue you. So that is the condition. So unless these kind of laws are there, or unless these kinds of rights are available, you cannot protect your rights. Your published work can be taken by anybody and distributed, and they can make money out of it. So isn't it not worthy of it? So the Copyright Act is protecting the owner from being copied by others. Then comes a patent. Any new invention that holds the potential of being put to commercial use is protected by the infringement or duplication by a patent. The patent is all about the invention, and when you invent a product, the right to produce that product remains with you. So there are two types of patent, that is process patent and the product patent. If you get a product patent, you are getting the right to make that product. Nobody can make that product anymore unless you get the permission from the registered owner. The process patent is that you get the patent for the process in which you can make the product. So if the process is different, it is possible that you can make a product by a different process. Then you have the industrial designs, and these are features such as shape, pattern, ornament, or composition applied to a product by an industrial process such as chemical process or mechanical process. So industrial designs are important when it comes to the industries or the manufacturing firms. So it could be in the form of a pattern or shape or ornament or some composition. So for this also you will be able to take up registration. So that is known as the industrial design registration. Then you have the geographical indications. So geographical indication is a name or sign used on certain product that marks the identity of a particular geographical location or origin. So for example, West Bengal holds the geographical indication tag for Rasgulla, and it is connected to a geography, and only those registered producers in that geography has the right to make that. So there could be some kind of a peculiarity with that that is connected with the geography. For example, you might remember, there are a lot of handlooms which are associated with the geography. In Kerala, you can just find Chendamangalam handloom, Kutambuli handlooms and Balaramapuram handloom, it is having certain kind of specialities which is connected to the place from which it is originated, and there are some registered producers who have the right to produce, and all other fake products will not be covered under the geographical indication tag, and nobody other than these registered producers are able to produce this products under this brand. So, which are the Indian laws to protect the intellectual property? So, there is a Trademarks Act of 1999, the Trademark Rules of 2002 and 2017. The other acts are the Patent Act of 1970, the Copyright Act of 1957, the Design Act of 2000, the Design Rules of 2001, the Geographical Indications of Goods Registration and Protection Act of 1999, the Semiconductor Integrated Circuits Layout Design Act of 2000, the Protection of Plant Varieties and Farmers' Right Act of 2001. So, these are the specific laws, Indian laws to protect the intellectual property. So, how to protect your intellectual property in India? So, intellectual property laws in the country are designed to support innovation and research. In order to reap the benefits of the intellectual property rights in the country, the first step is to register your creation. You can register your intellectual property for patents, trademarks, or copyrights. And in case of an infringement, you can challenge the same as civil disputes in the court of law. And if you are succeeding in filing this infringement and you get a positive kind of an order from the court, you will be eligible for a compensation as well from the person who has infringed or has made an infringement onto your rights. So, intellectual property is something what is valuable. So, don't think that if you have an invention, you just go for commercializing it. If the people find that that is a good product which is not protected by the patent, the very next day itself you will be able to just find the replica of the same product into the market. So, in order to avoid that, you should be very vigilant. The entrepreneurs should be vigilant, the startups should be vigilant, and they should be taking a patent for what they have produced. So, for the innovation also, the patent rights could be just applicable. So, what are the advantages of intellectual property rights? So, the first thing is ownership, and in a competitive world, the entrepreneurs, businesses and researchers are constantly trying to outdo each other. A determining factor to win this competition is ownership of creation, and intellectual property rights ensure that the creator holds the sole authority over their creation. Then another aspects could be infringement. With the intellectual property rights, creators are protected against the competitor illegally contravening on the creation. And for example, an entrepreneur's scientific invention is their own, and they are sole owner of the creation and can choose to do what they do to or what they wish to do with it. Anybody using the scientific invention for any purpose without paying due credit or royalty to the creator is liable to face the legal action. So, the ownership, not only that it creates a ownership feeling for the individual, it provides a protection against the infringement, that is unauthorized access or use of the property will be taken to the court of law. Then the next aspect is commercialization. Intellectual property rights are of great importance when the creator wishes to commercialize their product. It paves the way for the creator to issue the license for mass production of the product in exchange for monetary benefits and royalty. So, the commercialization is the aspect in which you have a technology that is ready to commercialize, and somebody who wants to use the technology, of course you are ready to give it, but only at a price, because you have involved in the creation of that particular technology and all your inputs are there. So, you have every right of commercializing it, and you have to be paid some royalty for that purpose, for the technology transfer. So, that is the purpose of it. So, patent rights or the intellectual property rights provides that facility for commercialization of your invention. Then learning. While registering a new intellectual property, the creator has to reveal the details of the product to the general public. And this practice encourages a culture of sharing of the information that can be further used for the development of the contemporaries in the field. And there is a point like, when you are disclosing this to the public, it will not be just copied by the public because you are the person who is getting the patent rights for that purpose. So this provides a arena for learning or disclosing of the information without any threat to just deceiving without your permission. Now, what are the strategies for protection and exploitation of the IPR for startups? So, the first thing, what could be the strategies, or having an invention, and when you are running after commercializing it, patent or filing your intellectual property rights is going to be another burden on the entrepreneur. You have to think about a lot of things, and in addition, what you have to just think about the IPR. But you cannot just avoid thinking about IPR, because that is going to be one thing which is preventing the competitors. So making intellectual property protection has to be a priority, and startups cannot afford the complete protection available under this intellectual property regime. And the first step for any startup is to evaluate and prioritize the IP rights involved in its business. And depending upon the type of industry involved, IP rights play an important role. And failure to identify or prioritize IP rights is likely to create problems for the startup's business, especially during the negotiations with the future investors or existing business. Sometimes IP rights are only asset available with a startup. No other rights are available, and if you are not having the protection, sometimes what happens is that some investor who is coming in to invest with you will be leaving away with all your rights. So that is one thing what you have to just see. The intellectual property rights protection has to be a priority. Then what you can do with it, the strategy, what strategy you can use for that, you have to register the intellectual property rights. It is important to note that certain IP rights like patents and designs are required to be registered before claiming any protection under respective statutes. On the other hand, certain IP rights like trademark and copyright need not be mandatorily registered for protection under. And nevertheless, a registered IP right carries a greater value and acts as evidence of use of IP rights before courts as well as enforcement agencies. Then, due diligence of IP rights. For any startup, it is indispensable that it does not violate IP rights of any other person. This will ensure safety from unwanted litigation. So just like you cannot use another people's or your property cannot be used by other people's, it is also true that you should not be using other people's property, and you should ensure that whatever things you are coming up is not moving into infiltrating with the rights of any other persons. And this makes it even important for the startup to make a careful IP decisions in the initial phase and conduct proper due diligence of the IP rights which it is using or intends to use. Implement clear and effective policies and strategies for protection of the IP rights. So this is very important for the startup. So it is in the long-term interest of the startups to have a intellectual property policy for the management of the various IP rights which may be presently owned, created or acquired in future by the startups. The aim of such policy is to ensure that there is no interstate dispute between the promoters of the startups, which remain till date to be one of the main concerns of the failure of the startup. So this usually happens like a startup, maybe he or she is having, who is the founder may come up with a particular technology, and that could be the only asset that is that the startup is having. And when a funder comes, he also becomes a co-founder by participating in the equity, and that person also owns up or tend to own the IP of it in a later stage if you are failing to own the IP. So the startup policy or the policy of the startup regarding the IP rights has to be clear, and to which extent the other people can be involved with the IP rights, All these things has to be very clear. So the policy, you need to make a policy and go with the policy. And agreements, what you have to do with the agreements related to the intellectual property. And it is pertinent to note that having proper documentation in the form of agreements like non-disclosure agreements, agreements with employees or independent contractors can make all difference between the success and failure of startups. So business secrecy is one major thing that the startups have to just think about. And also when you are having these kind of properties, that's the intellectual property, the unique selling proposition or something what is very innovative in your product or service that you are offering, and you have to keep it a secret, proper agreements have to be executed for that purpose. And usually intellectual property is created either by the founders or some key employee or a third party, and the intellectual property so created must be protected through a proper agreement between the founder or key employee or a third party, as the case may be, and the startup. So there should be a perfect policy for that. There is no specific requirement like this has to be like this. It depends upon the startup and how they have to fare with their own policies or creating the agreements with all these people. Now regarding the agreement, if the agreement with the founders or employees or a third party under which this novel idea was created is overlooked, it could create bottlenecks later after the idea becomes successful. So this usually happens, as we said, this is one of the reasons for why many of the startups fail. There could be discussions and also claims for the success, and also the claims for the IP rights, and all these things could arise if such policy is not arising. And accordingly, the startups need to ensure that anything created on behalf of the startup belongs to the startup and not the employee or the third party. So that is one major strategy what the startups can follow. And further, it is advisable to enter into elaborate assignments, licensing of user agreements, and care should be taken to make provisions for post termination of IP rights issues. So all these things should be taken care of, how do you execute the startup, the intellectual property policy of the startup, and how it has to be divided, and who generates that invention, and who has to get the IP rights, and how you will be dealing with the IP rights. All these things has to be taken care of when it comes to a startup. And what are the facilities that are provided by the Startup India mission for this filing of the patents? Actually, it is an expensive kind of a proposition and takes too much of time, and it requires expertise. So in order to facilitate this IP protection for the startups, the Startup India mission is providing a lot of support for the startups for creating or filing the patents, and financial support is also provided for filing these patents. So innovation is the bread and butter of the startups, and since patents are a way of protecting innovative ideas that give your company a competitive edge, patenting of your product or process can dramatically increase its value and value of your company. So that is very much important. So the innovation has to be protected. So that adds to the value of the company, or otherwise, it can happen anybody in the market will be coming up with copies of your products or copycats. And filing of the patent has been historically very expensive, as we said, it could cost you a fortune. And it is a time consuming process which can be out of the reach of many startups. And the objective is to reduce the cost and time taken for a startup to acquire a patent. So what Startup India mission does for this. So the objective of the Startup India mission is to provide support financially and also in the filing process. So what are the benefits that is available to the startups? They have the fast tracking of the startup patent applications. The patent applications filed by the startups shall be fast tracked for examination so that the value can be realized sooner. So when you file for your patent application, there's a search process what is happening. So the patent search, the search goes you have to just find out as to whether such kind of a thing, an idea or a product exists. So this usually consumes a lot of time. So there is a facility like, fast tracking of the startup patent applications can be done, which actually provides the startups an impetus in terms of the value can be, you get a patent better in earlier, so that the value can be realized sooner. Then panel of facilitators to assist in the filing of the IP applications. For effective implementation of the scheme, the panel of facilitators shall be empaneled by the Controller General of Patents, Designs and Trademarks, who shall also regulate their conduct and functions. The facilitators will be responsible for providing general advisory on different intellectual property as well as information on protecting and promoting intellectual properties in other countries. Then government to bear the facilitation cost, and under the scheme the central government shall bear the entire fees of the facilitators for any number of patents, trademarks or designs that a startup may file, and the startup shall bear the cost of only the statutory fees payable. So there is a kind of a facility which is available to the startups. Then there is a scheme called the Startups Intellectual Property Protection Scheme, SIPP. This is launched by the Government of India. This facilitates the startups to file the applications for patents, designs and trademarks through registered facilitators in appropriate IP offices by paying only the statutory fees. And under the schemes, one of the facilitator is the NRDC, National Research Development Corporation. They provide general advisory services on different intellectual property on a pro bono basis. They provide information on protecting and promoting IPRs to startup in other countries on a pro bono basis. They provide assistance in filing and disposal of IP applications related to patents, trademarks and design under relevant acts at the national IP offices under the CGPDTM, drafting of the professional and complete patent specifications for inventions of startups, preparing and filing responses to examination reports and other queries, notices or letters by IP office, appearing on behalf of startup at hearings as may be scheduled, contesting opposition if any by other parties and ensuring final disposal of the IPR application. So these are the steps which are involved in filing an IP, and what is the mandate of NRDC in acting as a facilitator. So similarly, you have other facilitators as well, which provides the advisory services and the support services in filing your patent and getting your patent. So what is a patent reimbursement? So this is in the patent reimbursement that is available from the Kerala government. They likewise, state governments are having the patent reimbursement facilities, where the other state governments also might be having. And Kerala government, through its Kerala Startup Mission, has launched a scheme called Patent Support Scheme, where the support is provided for startups and student entrepreneurs who are able to secure a patent. And the patent support system intends to support startup entrepreneurs and student entrepreneurs by reimbursing the patent cost, including consultation fee, subject to a limit of rupees 2 lakh per Indian patent awarded. And for the awarded foreign patents on a single subject matter, up to rupees 10 lakh would be reimbursed. And the reimbursement will be done in 3 stages during filing, prosecution and award. So this is the facility which is available for the startups for patent reimbursement. So likewise, a lot of facilities regarding the protection of IPRs is available under this IPR facilitation regime for the startups under the Startup India Mission scheme and also under the state startup mission schemes. So it is for the startups to avail this facility and get the support of the government in protecting their intellectual property, which would guard them against the competitors' strategies. So thank you.